golden silence, the legality and morality of NDAs, disparagement clauses, and corporate bribery. Introduction. In the modern corporate landscape, the delicate balance between employer and employee rights has become increasingly skewed, favoring those in positions of power. Non-disclosure agreements, NDAs, severance packages, and disparagement clauses have become common tools of corporate America, wielded not only to protect legitimate business interests but also to silence dissent, cover up wrongdoing, and manipulate the narrative. This essay argues that these mechanisms, while legally binding, often border on coercion and bribery, raising serious ethical and legal concerns. The legal foundation of NDAs and disparagement clauses. Non-disclosure agreements, NDAs, and disparagement clauses were initially designed to protect companies from the unauthorized disclosure of proprietary information and to maintain a company's reputation. However, the scope and application of these agreements have expanded far beyond their original intent, transforming them into tools of control and suppression. The expansion of NDAs, a tool of silence. NDAs were originally intended to safeguard trade secrets and other sensitive business information. However, in recent years, their use has broadened to include the suppression of any information that could potentially damage a company's image, including instances of workplace harassment, discrimination, and other unethical practices. This expansion effectively gags employees, preventing them from speaking out about issues that are not only personal grievances but also matters of public concern. Disparagement clauses, often included alongside NDAs in employment contracts and severance agreements, further restrict an employee's ability to communicate freely. These clauses typically prohibit any statement that could negatively impact the company, its products, or its leaders. The vagueness of such terms allows companies to interpret any criticism, no matter how justified, as a violation of the agreement. This effectively muzzles former employees, making it impossible for them to speak truthfully about their experiences without fear of legal repercussions. Case law and precedents. While there have been instances where courts have invalidated NDAs that were used to cover up illegal activities, these cases are the exception rather than the rule. In most cases, courts have upheld the enforceability of these agreements, placing corporate interests above the rights of individuals. This judicial bias underscores the significant power imbalance that exists between corporations and their employees. The legal system, which should protect individuals from coercion, often ends up reinforcing it, leaving employees with little recourse but to comply. Severance packages as golden handcuffs. Severance packages are often portrayed as a generous parting gift from the employer to the employee. However, these packages frequently come with strings attached, strings that can entangle employees long after they've left the company. These golden handcuffs are designed not to ease the transition of departing employees, but to ensure their silence and compliance. The allure of golden handcuffs. Severance packages, especially those offered during layoffs or other mass departures, can seem like a lifeline to employees who suddenly find themselves without a job. However, these packages are often contingent upon the employee's agreement to additional NDAs, non-disparagement clauses, and covenants not to sue. The financial benefits of the severance are thus tied to the employee's willingness to forfeit their rights that are critical to holding companies accountable for wrongdoing. The coercion is subtle but undeniable. By offering a financial safety net, companies create an environment where employees feel compelled to accept the terms, no matter how restrictive or unfair. This is not a gift, it's a transaction, where the employee's silence is the commodity being bought and sold. Financial coercion in a precarious job market. The precarious nature of today's job market only heightens the coercive power of severance packages. With the threat of unemployment looming large, many employees feel they have no choice but to accept these golden handcuffs. The severance package becomes a financial lifeline, but one that is tied to the forfeiture of fundamental rights. This dynamic creates a chilling effect where employees are dissuaded from speaking out about their experiences for fear of losing their severance. The result is a corporate culture that prioritizes silence and compliance over transparency and accountability. The morality of financial coercion. The ethical implications of using financial incentives to enforce silence are profound. When companies exploit the financial vulnerability of their employees to secure NDAs and non-disparagement agreements, they are engaging in a form of corporate blackmail. This practice not only undermines the individual's rights, but also deprives society of valuable information about corporate practices that could have far-reaching implications. This is not just a legal issue, it's a moral one. The use of severance packages as golden handcuffs is a reflection of a corporate culture that values profit over people and secrecy over accountability. It's a practice that must be called out and challenged if we are to create a more just and transparent business environment. The thin line between severance and bribery. At what point does a severance package cross the line from being a compensation for service to being a bribe? This is a question that sits at the heart of the debate over NDAs and non-disparagement clauses. When companies use financial incentives to secure silence, they are engaging in behavior that is alarmingly similar to bribery. The nature of bribery. Bribery, at its core, is the exchange of something of value for influence or action. In the case of severance packages tied to NDAs, the company is effectively paying the employee to keep quiet. While this may not fit the traditional legal definition of bribery, it shares many of the same characteristics, a powerful entity using its resources to buy the silence of those who could expose its wrongdoing. This is particularly concerning when the information being suppressed is of public interest. When employees are paid to remain silent about illegal or unethical practices, the company is not just protecting its reputation, it is actively obstructing justice and denying the public the truth. Corporate bribery in disguise. The inclusion of NDAs and non-disparagement clauses in severance packages is a calculated move by companies to protect themselves from potential fallout. By tying financial benefits to silence, they are engaging in a form of corporate bribery. This is not about protecting trade secrets or confidential information, it's about controlling the narrative and avoiding accountability. The legal system, unfortunately, has been slow to recognize this practice for what it is. While there are laws in place to prevent outright bribery, the use of severance packages as a means of buying silence remains largely unchecked. This is a loophole that companies have exploited with alarming frequency and one that needs to be addressed through legal reform. Case studies: corporate silence and bribery. There have been numerous instances where companies have used severance packages to bury scandals and avoid legal repercussions. From tech giants to financial institutions, the practice of paying off employees to secure their silence has become a common tactic in the corporate world. These cases highlight the ethical and legal gray areas that exist when it comes to the intersection of money and morality. The public has a right to know about the practices of the companies they patronize, and employees should not be forced to choose between their financial well-being and their moral integrity. It's time to shine a light on this shadowy practice and hold companies accountable for their actions. The First Amendment and public interest. They are infringing upon the fundamental right of individuals to speak freely about matters of public concern. The First Amendment conflict. The First Amendment guarantees the right to free speech, yet NDAs and non-disparagement clauses are designed to limit this right. While these agreements are legal, their use to silence employees can be seen as a form of corporate overreach. The question that arises is whether these contracts should be allowed to supersede constitutional rights, particularly when the information being suppressed is of public importance. This conflict between contractual obligations and constitutional rights is at the heart of the debate over NDAs. When an employee is forced to sign away their right to speak in exchange for financial compensation, their First Amendment rights are effectively being sold to the highest bidder. The whistleblower's dilemma. Whistleblowers are particularly vulnerable to the coercive power of NDAs. These agreements are often used to prevent employees from reporting illegal or unethical practices to the authorities. While there are laws in place to protect whistleblowers, the reality is that many are still silenced by the threat of legal action if they violate their NDA. This creates a chilling effect, where employees are dissuaded from coming forward with information that could be vital to the public interest. The fear of legal repercussions, combined with the financial incentives of severance packages, leaves many whistleblowers feeling trapped and powerless. Ethical responsibility versus legal obligation. The ethical responsibility of employees to speak out against wrongdoing is often at odds with their legal obligations under NDAs and non-disparagement clauses. This creates a moral quandary, where individuals are forced to choose between doing what is right and protecting themselves from legal and financial harm. This is a choice that no one should have to make. The legal system must recognize the importance of protecting whistleblowers and ensuring that NDAs are not used to shield illegal activities from public scrutiny. Companies should not be allowed to buy silence at the expense of the public good. Conclusion: a call for legal reform and corporate accountability. NDAs, disparagement clauses, and severance packages are tools that, while legal, often serve to perpetuate a culture of silence and impunity within the corporate world. These agreements, when used to suppress speech and buy silence, raise serious ethical and legal concerns that cannot be ignored. It is time for a re-evaluation of the laws governing these practices. Legal reforms are needed to ensure that NDAs are not used to cover up illegal activities and that employees are not coerced into silence through financial incentives. Whistleblower protections must be strengthened, and the use of severance packages as a means of buying silence must be curtailed. Corporate accountability is not just a legal issue, it is a moral imperative. The public has a right to know about the practices of the companies they support, and employees have a right to speak the truth without fear of retribution. The time has come to shine a light on the dark corners of corporate America and hold those in power accountable for their actions. We must challenge the status quo and demand a corporate environment where transparency and integrity are valued over secrecy and control. Only through legal reform and a collective commitment to ethical behavior can we ensure that the rights of individuals are protected and that the public good is upheld.